IPR management. IPR as such, and big thanks to the Controller General of Patent, Design, Trademark, and Copyright, Professor Unnat Pandit, for agreeing to join, us in this particular webinar, and just enrich us with his experience and his advice on how organizations like CSIR can benefit from the whole thing. When we talk of biodiversity, biological diversity, what exactly comes into the mind of any researcher are just two aspects which are very, very important. And that's the crux of, at least I feel that's the crux of the entire biological diversity that we talk about. One is sustainability. A sustainable ecosystem which will really help us, as humans, as living beings in this planet, to actually, continue as is in this particular world. And the second aspect that comes in is to give due recognition to those who have helped in sustaining this diverse ecosystem of ours. Of course, there would be more aspects, but according to me, these are the two major aspects and the crux of the whole biological diversity and what the convention says, and also what our rules, our regulations, and our norms, be it the norms at the National Biodiversity Authority or the norms at the Patent Office or the IP offices, the other IP offices, they say. But without spending too much time on all these things, I think I'll leave the experts. And what better expert than Professor Pandit, the Controller General of Patent, Design, Trademark, and Copyright, to be here with us and to give us his, not only his thoughts in this particular area, how there's such a good connectivity between biodiversity and IPR per se, and what exactly is required from an organization like ours when we are working on different aspects of biodiversity and we are using biological material. So it's over to you, Professor Pandit, and thank you so much once again to joining in this particular webinar. Please. Thank you.
Thank you, Vibhaji and the CSIR team for planning such a wonderful virtual event. I can say it is on time. Of course, the National Biodiversity Day was on 22nd, and it's a coincidence for each one of us that we are planning this event on 24th May 2024, which is the historical day for entire world. Just before few hours in Geneva at WIPO, the diplomatic conference is going on. And in this diplomatic conference, all the member states have concluded the text of international legal instruments related to intellectual property, genetic resources, and traditional knowledge associated with genetic resources. And this has been unanimously agreed by all the WIPO member states. It's up to up to member whether they are going to access this or they are going to be part of this treaty or not. But certainly the text is concluded, and I am having this text in front of me. Vivaji, I have also shared this text with you on a WhatsApp. And I must submit here that on biological resources or biodiversity or genetic resources, India is taking a global lead here. We are duly recognizing the traditional knowledge associated with the genetic resources. And there are so many provisions in this treaty wherein India has made the impactful submission representing the global south. In a way, India has become a voice of a global south. And this is positioning India as one of the pioneering leader in the IP space. As we say that India is growing in IP front, recognizing the true creative contribution has always been our position. We have started with recognizing the contribution of our inventors, our invention, specifically in the biological resources. We have ensured that wherever the non-codified reference which is being used, we must give the citation. And we must recall our journey in this space by ensuring that there is a no me too kind of a patent which was given by the developed country in basmati or haldi that has triggered the attention of all the scientific fraternity, that how can this possible? And then CSIR has played a pioneering role in creating the traditional knowledge digital library. And when I was there in Geneva last week, this was a major submission, that one of the way through which we can recognize the reference of traditional knowledge through TKDL. See the visionary step taken by the Government of India and lead by the Council of Scientific and Industrial Research, CSIR. And that sets the tone how the genetic resources or biological resources need to be handled, especially in reference to the intellectual property right. We have a reference in our application. Still, there is a need for further optimizing or aligning our Biodiversity Act to the global need. Certainly, there are provisions which are reformed in recently enacted Biodiversity Act. This shows the vision of the Government of India, that how we want to deal with the research on the biodiversity or a genetic resource related invention. Clearly, in section 6 of the newly enacted Biodiversity Act 2023, it is allowing researchers to just merely register the use of a biological resource on the competent authorities' website. And once this is used, it can also become a part of our formal referencing in the specification and in the application form. So without going much into the complex nitty-gritty which was there in the Biodiversity Act 2002, This is one of the bold pioneering steps taken forward by the government of India. And this is certainly getting reflected in the form of the international treaty also. There are so many provisions under which India has raised a voice of a global south. And this is further going to be utilized by 193 countries. If they are not going to be a part of this treaty, in that case also, any such application which is entering into the member state of this treaty will have to comply with the requirement which is commonly agreed before few hours. To be specific, in the Geneva time, late night or our today morning 6 o'clock and Geneva time 2:30, this text was agreed by the members. And today around 2 p.m., which is going to be around 10:30 of the Geneva time, all the member states are going to formally accept this on a plenary session. India became a voice of a global south. And this is a proud for each one of us, especially the CSIR, who has taken a far-sighted vision a few decades before. And this movement has taken up a useful intervention from India in this treaty. I will go one step back. When the special session was called by the WIPO for preliminary discussion on the proposed text to this treaty, India has made a paper which represents our voice on the genetic resources. And our voice was accepted by many Asia Pacific region countries, African countries, many ASEAN countries, including the Brazil and the South American countries also. That has given the strength to Bharat. And Bharat is now truly a leader, emerging as one of the key players in WIPO. This has become collectively because of each one of us who are doing a pioneering work in advancing the traditional knowledge through modern science. It is a time for India. ये हमारा समय है, जो प्रधानमंत्री जी भी कहते हैं ना कि ये हमारा समय है, ये सही समय है, और इस सही समय में हम सबको साथ मिलके आईपी गिरी करना है. We need to innovate solution for the problem which country is facing, society is facing. Role
Professor
of a
Pandit,
scientist in next 2 decades.
If I may just intervene, can I request all participants to please mute themselves? All participants are requested to please mute themselves. Thank you. Please, sorry, please continue, Professor Pandit.
Yeah. So I was just referencing to each and every scientist. भारत को विकसित भारत बनना है, तो विकसित भारत में हर वैज्ञानिक की, हर रिसर्चर की एक अहम भूमिका है. I know I am changing the language of my submission, but कई बातें ऐसी होती है जो हमारी संपर्क भाषा में बहुत अच्छे से कह सकते हैं. And I'm sorry, I'm going into the Hindi because जिस भाषा में मैं सोचता हूँ उस भाषा में अपने विचारों को बेहतर रूप से व्यक्त करना, ये भी मेरा एक विचार है। आने वाले 2 दशक में हम सबको साथ मिलके ट्रेडिशनल नॉलेज संदर्भ में कैसे नए अनुसंधान होने चाहिए, how we can set a tone of a traditional knowledge and bioresource or genetic resource related invention addressing the need of our country. Ashwagandha has been a talk of our town, and with the help of Ayush Ministry and the TKDL, we have set one pavilion in this diplomatic conference. This pavilion was again a center of attraction for this diplomatic conference. We have shown that how India has approached in last couple of decades utilization of a traditional knowledge using the modern science and trying to innovate something which is added knowledge, outright having a novelty, inventive step, and the industrial applicability. And for preparation of this particular pavilion, we have scanned through the last 10 years literature. More than 450 such innovations Indian researchers have done during last 2 decades. And giving a due respect to the biological resources, citation, but something which is not known into the traditional knowledge, like use of ashwagandha for subsiding the side effect during the chemotherapy for the cancer treatment, which is nowhere known into the literature. Now this has been accepted as one of the frontline therapy by many oncologists in the country. Same way curcumin oil, which is the extract adopted from the haldi, but use of this curcumin oil as an adjuvant to the therapeutic effect, which was not known into the literature. This has again been protected through IP. There are several such things. In TKDL itself, we have more than 8,000 medicinal plants reported. How we can utilize the knowledge which is in existence and advance to the newer therapeutic effect. Connecting the traditional knowledge or genetic resources, utilizing the modern science for the advancement to serve the society, offer a solution to the critical diseases is going to be the way forward in next 2 decades. I am sure this historical success will motivate each one of us to rethink our strategy on intellectual property creation, and this creation is the IP Giri which we have to offer to the India and the solution to be offered to the world. ये हमारा समय है, ये हमारा आईपी गिरी करने का समय है। हर वैज्ञानिक को, हर अनुसंधानकर्ता को अपने आप को नेक्स्ट 2 दशकों के लिए कमिट करना है कि विकसित भारत में मेरी, हमारी, हम सब की क्या भूमिका रहेगी। जितने भी बायोटेक्नोलॉजिस्ट हैं वो भी सोचे कि कैसे हमारे नए अनुसंधान की प्राथमिकता होनी चाहिए और कैसे इस प्राथमिकता के ऊपर हम सब साथ मिलकर प्रयास करें. We need to create a groups within this space and try to specialize the advancement of our research. I think that is going to be the future for the biodiversity and genetic resources related research and innovation in India and in the world, and how we can take the leadership. This leadership is going to be achieved with our hard work, our commitment, and our designing the solution for the Indian need and advancing to the global need. I think that would be the biggest message on this event organized by the CSIR. Let's take an oath on this occasion. You don't need to tell anybody what we are going to do. You need to tell yourself what is going to be your contribution in this next 2 decades. When every day we see the mirror to dress up ourselves, spend few seconds what you have contributed yesterday, what is your commitment for today, and what you are going to do tomorrow. As a scientist, as a researcher, for glorifying the commitment of our country towards a Viksit Bharat at 2047. I thank CSIR, especially Dr. Vibha Malhotra ji, for giving me the opportunity to share my thoughts as part of this National Biodiversity Day celebration organized by CSIR. Thank you very much. Namaste.
Thank you so much, Professor Pandit, for setting the tone of the deliberations further. And I'll thank you once again for agreeing to stay on and join the panel discussion also, because we have in the panel discussion, we have Professor Archana Chugh also from IIT. So warm welcome. She's been there right from the morning. Professor Chugh, thank you so much.
Thank you. Thank you very much
for joining this webinar of ours. And thank you. So just a brief thing. My colleague Lipika will now just very briefly touch upon what are the amendments in the new Act of Biodiversity, which CSIR had, of course, given our inputs and all. And I'm happy to share that whatever inputs we had given, all of them were accepted by the NBA, the MOEFCC, and NBA for the Biodiversity Act. But just a brief thing, briefly, Lipika is going to explain what all we had suggested, and all that has been included in the new Biodiversity Act, and what are the various amendments made which are going to have an implication on our IPR management within CSIR. So it's over to you, Lipika, to just take us through the thing. Yeah.
Thank you, ma'am. And good morning, all. So I'll be talking about the changes that has been made into the Biological Diversity Act by the recent amendment, and I'll try to focus on the amendments which has impact on the IP protection and IP management. So as we all know, the India became a party to the CBD in 1992, which was further ratified in 1994, and towards the obligation towards CBD, the Biological Diversity Act was enacted in 2002 with the objectives of conservation of biological diversity, its sustainable use, and fair and equitable sharing of benefit that arise from the utilization of the biological resource and traditional knowledge. And in 2004, the rules were laid, and in 2014, the ABS regulation, that is the guidelines, were notified. So here I want to mention that the intent of this enactment was really noble, really for a good cause. But some provisions of the law of this law pose some challenges on the R&D organization, on industry, on the organization which were actually utilizing the biological resource in their research or commercialization or even filing IPRs. So some of the few provisions which were so challenging, I'd like to focus. First of all, the definition of foreign entity. So basically, it said that it is provided under Section 3.2. It said that body corporation, even if it is registered in India, if it has non-Indian participation in its share capital, then it will be considered as a foreign entity according to this law, or for the provisions of this law. And even if the share capital is 1%, it will be considered as a foreign entity. So this was a very major challenge. Second was the definition of biological resource. Few terms in this definition were ambiguous, and which was leading to different interpretation by different stakeholders, by different government organization, even by the courts, and it was ultimately leading to different interpretation of the provisions of the law. And then one of the other challenge was the linking of grant of IPR to execution of ABS agreement. Particularly, it was leading to pendency with the IP office and delay in the grant process. And of course, the penal provisions, which was discouraging for the research and commercial utilization of biological resource, particularly from India. So it has led to a situation where research in this field was slowing down, and people were trying to get biological resources from outside India so that they can escape the provisions of this law, or some industry were also trying to shift their base to other countries. So at this point, the stakeholders approached the government departments to reform this particular law, and the law now has been amended with which is enforced from 1st April 2024. There are few terms which need further clarification. We hope we can get that clarification in the future rules and guidelines. But I still want to mention that the substantive amendment that has been done to the major portions of the law is very positive and in interest of Indian R&D and Indian industry. So in particularly, I will have a few slides to show what are the amendments that are actually done. So basically, ma'am, is my screen visible?
Yeah, it is. Please go ahead. Just put it on slideshow mode. No, yeah. Just put it on slideshow mode, Lipika.
Is it in slideshow mode?
Yeah, it is now. Please continue.
Thank you, ma'am. Actually, I'll be talking about the amendments that has been done to the definition section, which will impact IPR, then to the substantive part of the law, particularly section 327, amendment in the exemption provided in section 40, and of course the decriminalization of this act. So basically, in India actually, India signed the Nagoya Protocol in 2010. So the principles of this protocol are now been included in the preamble of the amended act. And now moving to the definition section, few definitions are added, new definitions which are added at this point, and few were revised. I'll only focus on those which were actually pertaining to or related to IPR. A term access has been added. It means collecting, procuring, processing biological resource occurring in obtained from India, associated traditional knowledge thereto for the purpose of research, biosurvey, and commercial utilization. This particular term is referred in many sections, so it is an important term now. Next is codified traditional knowledge. It means it is a knowledge derived from the authoritative books specified in the first schedule of the Drugs and Cosmetics Act. These are the list of references provided there. And a new term derivative has been added, which means naturally occurring biochemical compounds, metabolism of biological resource, even if it doesn't contain a functional unit of heredity. So basically, it is borrowed from the Nagoya Protocol, and it includes biochemical compounds existing in the biological resource, its products and byproducts as well. So now coming to those definitions which are amended. Basically, the definition of biological resource is now amended, which include plant, animal, microorganism, or part of their genetic material derived from, derivatives, excluding value-added products, and which has actual and potential use or value for the humanity, and it doesn't include human genetic material. So basic amendments here are the term include. It is an inclusive term, and it also referred to those part of the biological resource which contain the genetic material, and the term derivative covers all the products, byproducts, and biochemical compound that is present in the biological resource. And another definition, biosurvey and bioutilization has now been delinked. Bioutilization was considered to be something that is to be done in the lab scale, and biosurvey was something to be done with the field scale. So they are delinked now and defined separately. Now coming to the amendment in the substantive part of the law. So section 3 has been amended, particularly section 3(2)(c)(2) has been amended, and it says that a body, corporate, or association, organization that is incorporated or registered in India and which is controlled by a foreigner within the meaning of section 227 of the Company Act 2013. So what is the summary, or what is the effect of this amendment? Actually, this biodiversity law is supposed to be liberal to Indian and stringent to non-Indians, because it is the Indian biodiversity we are talking about. And according to the previous law, or the principal law, only if, as I have mentioned, even if there is only 1% share participation by a non-Indian, was making a company into a non-Indian entity or foreign entity. So generally, all the major companies in India, or the public companies, they are listed companies, and anyone can buy shares of those companies, and even foreign entities could buy. So this section there was a need to amend this particular provision or definition of section 3(2). Now with this amendment, reasonable characterization has been done, and based on the Company Act 2013. So now foreign controlled company means, according to the Company Act, it will be it is a company where the foreign entity or foreign person has the right to appoint majority of directors, or they have the right to control the management, or have the right to take policy decisions for that company. In case such a control is there, it will be considered as a foreign company, foreign entity, and the provisions of the law will apply accordingly. So now it is very clear what will be what is an Indian entity, what is a non-Indian entity, and it is done in a very reasonable manner. Now let's move to section 4. Section 4 basically says that the person no person shall share or transfer result of research on biological resource or traditional knowledge for monetary purpose or otherwise to a section 3(2) person without NBA permission, except codified traditional knowledge. So coming to the summary of this amendment, and further it also says that this provision will not apply to research publication and dissemination of knowledge. And in case the result of research is being transferred for further research, then registration with NBA is required. If it is transferred for commercial utilization or IPR, and in that case, NBA permission will be required. So coming to the summary of these things, basically, biological result of research is not to be transferred to 3(2) without NBA permission, and there are some inclusions. Basically, the access of biological resource access from India is introduced. Traditional knowledge associated thereto is included, and there is an exemption provided, that is codified traditional knowledge. So codified traditional knowledge has the definition which I have mentioned in the definition clause. Now let's move to the next section, that is section 5. So section 5 has been the amended section 5 is the amendment is basically done in section 5(1). It says that the provisions of section 3 shall not apply to collaborative research projects involving transfer or exchange of biological resource or traditional knowledge associated thereto between government sponsored institutes. So if some criteria are fulfilled. So basically the summary of this amendment is, originally, before amendment, section 3 and section 4 both were not applicable to collaborative research project where collaborative research projects between government entities or government institutes. But after amendment, only 3 section is not applicable. So 4 section will remain applicable. So if it is a collaborative research project, there is a transfer of result of research happening, even if it is happening to a government entity to another government entity under collaboration, the provisions of section 4 are required to be fulfilled. And Okay, now let's move forward to the IPR section. Section 6 is very greatly amended. Before amendment, Section 6 was applicable to both Indian entity, non-Indian entity, Section 32 person, non-32 person. And after amendment, Section 6(1) says that the Section 32 person who is applying for IPR based on invention, which is based on biological resource access assessed from India, or a biological resource that is deposited in a repository outside India, or traditional knowledge associated thereto, has to obtain NBA permission. So Section 32 person or foreign entity needs to obtain NBA permission. But Section 6(1)(a) says that the Section 7 person is the Indian entity. So if he wants to obtain IPR based on biological resource of India, he need to register, only register. And in case at the time of commercialization where he has obtained the IPR, at the time of commercialization, NBA permission is required to be sought. So in summary, before amendment, NBA permission was required to be sought by Indian as well as non-Indian. But after amendment, only non-Indian entities need to get permission from NBA. It means by executing ABS agreement. There are some inclusions into it. The biological resource access from India is added. Those biological resource which are there in deposited or repository outside India, if they are used, it is now included in this provision, and traditional knowledge associated thereto is included. And now coming to Section 7 person, Indian entity, they only need to register with NBA at the time of filing for IPR, and need to get the ABS agreement executed at the time of commercialization. And the most positive thing here is the patent grant will not be affected by the grant will be done without NBA permission. Now moving to Section 7. Section 7 actually says that no person other than 32 person, so it is basically referring to Indian entities, shall access biological resource associated knowledge for commercial utilization without prior information to SPBs. And this provision doesn't apply to codified traditional knowledge, medicinal plant, cultivated medicinal plant and their products, local people, communities, growers and cultivators of biodiversity, Vaid Hakims, registered Ayush practitioners. And about this cultivated medicinal plant, it says that they will be requiring a certificate of origin from the BMCs. So here, coming to summarize this thing, Vaid Hakims and local people, communities, cultivators and growers were previously, in the previous act also they were excluded. Now there are some addition to exemption, particularly Ayush practitioners, codified traditional knowledge and cultivated medicinal plants, because they are cultivable, they are not going to be get extinct. Now coming to Section 40, Section 40 basically says that the central government, in consultation with NBA, will can declare that the provisions of the Act will not be applicable to biological resources which are traded as commodities. This till this part, it was there in the previous Act as well. Now it has been expanded to items derived from that. It means product of the traded commodities, agricultural waste, cultivated medicinal plants, but no exemption is provided in case of IPR. So these are the additional inclusions. But in case if it is IPR, then all the provisions of Section 6 are to be fulfilled. Now moving to the next section, basically Section 55 provides for pecuniary remedies in case of contravention of the Biological Diversity Act. And it also talks about appointment of an adjudicating officer. And coming to Section 58, which was previously talking about cognizable and non-bailable offense in case of contravention, is now omitted. So basically, the Act has been decriminalized. The penalty has been increased, and now there is a mechanism. An adjudicating officer will be appointed who will be actually looking after that the provisions of this part of the law are being fulfilled. So basically, I have tried to cover those provisions of the Act that may impact the protection of IPR, the transfer of knowledge or knowledge sharing relating to IPR, commercialization of IPR, and of course, in case some contravention happens which relates to IPR. And because the 3-2 person, I have focused on that point because our collaborators are 3-2 person in case they are foreign entities. Our co-applicant can become a 3-2 person in case they are foreign entities. So though the amendment to the Section 3.2 are also very important when it comes to IPR as well. So that's all from my side. I conclude here. Thank you.
Thank you. Thank you, Lipika, for summarizing briefly the amendments to the new act, the amended act, and any clarification or any further, discussion that needs to be done. CSIR scientists and others, researchers who are working in this domain, are most welcome to get in touch with IPU, and we'll definitely help in understanding the whole thing. I'll just pass on now to Bhanu to take care of the panel discussion. And so all of you, Professor Pandit, Dr. Archana Chugh, please do, maybe you could just Professor Pandit, can we see you?
Excuse me.
You could just yes.
I'm Arvind Singnegi from CMAP Lucknow. I have one from Dr. Lipika.
Yeah, please go ahead, Arvind. You want to take it right now or during the panel discussion?
Okay, later I can speak.
Sure. Yeah. So Bhanu will just take you through. She's the anchor for the panel discussion. So over to you, Bhanu, please.
Yeah, thank you, Dr. Vipa. And as you are aware that we have been organizing a program for Biodiversity Day every year since 2021. And this year we have chosen to do it on 24th. And as Dr. Unnat Pandit said, that this is an important day today because we are having a WIPO conference, and he disclosed the details of the conference along with to all the participants. And I'm happy that we are organizing this event today. And the panelists today that we are having for panel discussions are Dr. Karthikeyan Vasudevan from CCMB. He's part of CCMB team in Hyderabad, CSIR CCMB team in Hyderabad. He's looking after LACONS, which is for wildlife conservation and wildlife genetic resource conservation body. Second panelist with us today is Dr. Mahendra Darokar. He's sitting next to me. He is chief scientist at TMD and is also now part of Innovation Center team at CSIR Innovation Center at Mumbai. The third panelist today is Dr. Alka Rao. She has been part of CSIR IMTech and has been part of MTCC team, the microbial tissue culture collection team at IMTech, and is now part of SSAI as an advisor for food additives and for science and standards at FSSAI since March 2024. The fourth panelist is Dr. Archana Chugh. She is a professor at IIT Delhi and has been very active in IPR and legal issues regarding biodiversity, along with her other interest in plant-based therapeutics, marine bioprospecting, and cell-penetrating peptides. These are her area of research. So the first, Dr. Karthikeyan,
Professor Pandit is there to guide us all.
Yeah.
For any queries or anything on the IP matters.
I hope Professor Pandit will also participate actively and will provide guidance by points to us. So over to first panelist, Dr. Karthikeyan Vasudevan. I would like to pose a few questions, and I hope you will be able to, channel your talk on those key points. The first point that I would like to ask you is about because you're part of LACONS and because you're part of wildlife conservation. So first of all, what does the impact of, is there any impact of Biodiversity Act on the conservation aspects of, wildlife vis-a-vis what we are doing work in CCMB? Second point is, like, while you are, maintaining a facility which is for wildlife conservation and wildlife genetic resource conservation also, and you are participating in conservation of wildlife in terms of not only identifying which are the species which are getting extinct and how to then try to reintroduce or replicate and reintroduce some species in the wild. what is the impact of the Biodiversity Act, and does it hinder the R&D that we are doing at CCMB, or does it, help you in that? And what is the way forward, and what is the plan that you have like this year, because the theme is be part of the plan for biodiversity conservation? So what is the action plan that we are having from CSIR perspective for the wildlife conservation? I would like to inform you that Dr. Karthikeyan Vasudevan, if I'm not correct, you were part of World WII Dehradun also worked for some 14 years there. So he has a very long experience in wildlife conservation. So over to you, Dr. Vasudevan.
Yeah, thank you, Dr. Banu. Good morning to all, Dr. Vibha, for organizing this wonderful meeting. And we had a very nice introduction to the whole scenario with a very current information that Dr. Pandit brought, and very nice news that we have been able to convince a large international body to agree to some of the changes that need to be brought into the Biodiversity Act, and how we can play a many important role globally. So I'll go into the specifics. I think Dr. Banu has been helpful in directing me to the areas that I have to address. So I think it was Dr. Vibha who was initiating the whole process when the whole draft bill was placed, and we had several meetings. I was part of it, and Lipika was also there, and she has been steering some of these discussions with different CSIR stakeholders. And I have been through that journey where, we were discussing many of these changes. It's nice to see all those letters appear in the bill finally. So, which is a great achievement by itself. And congratulations to the CSIR team for doing this. So while the act is the changes are very significant, many of the acts, particularly if you take one of them hallmark acts of conservation, is the Wildlife Protection Act, which is in 1972, and now you have Biodiversity Act. Wildlife Protection Act is probably among the most amended acts in the acts that are there in the governance of in the government of India. That is primarily because many things change. Very rapid changes keep happening in the socio-economic milieu as well as in the environment. And the changes are very positive. Usually they take a very positive impact. Going by that, Biodiversity Act is more recent than Wildlife Protection Act. And this amendment is also an indication of the changes that we need to do to orient ourselves to the new socio-economic condition and the emerging value systems that we have with biodiversity. Having said that, I feel that the act has been a little narrowly focused, if I may say that, in specifying the stakeholders. Now, for example, Ayush is mentioned, Hakims are mentioned. They are mainly dealing with plants and the Ayurvedic system of healing or wellness through the derivatives which are plant-based. We all know that this is a huge market. India is probably a leader in this, and there is tourism attached to it. There is human well-being attached to it. But there are emerging markets. I would say a few here. For example, aquaculture. The need for new varieties of ornamental fish. India is going to become a very big player in the coming future. By narrowing the scope of the stakeholders who are participating in the recent amendments or specifying them in the act, we might, lose some of the important stakeholders who will have very huge impact in the future. And with respect to the situation that is there in the wild, in the wild, with all the biodiversity that we have, we all know that they are restricted to some pockets. They're doing well in most cases. Some cases we don't know, but some cases it's doing badly as well. But I feel that giving the power to the disaggregated or a little bit unorganized sector of hakims or traditional healers who are found in the local villages or accessing the bioresources which are nearby will lead to a little unregulated access to wild bioresources. And some of the cultivated bioresources might be more expensive to rear and manage than ease of access to the wild bioresources. For example, plants, some of the herbaceous plants which are medicinal, it might be still economically viable to exploit them from the wild than actually rear them and raise them in conditions, in more controlled conditions. So this is going to be a huge challenge. And in the same way, the Biodiversity Act is trying to regulate the access to the important bioresources that we have. I think it is more aspirational from the place I come from, which is in Lacones, that I would like to see some monitoring plans in place for the most high value bioresources, and how we have to even project those indices, whether they are doing well. If they are high value biodiversity resources which are being accessed and being used in the industry, then how are these resources faring in the nature? Are they declining? Are they staying stable? Or are they increasing? We don't have such yardsticks developed as yet. And I think while we open the channels for ease of access or ease of doing business with some of the bioresources that we have to be very cautious about not losing them in the native biodiversity that we have, bioresources that we have in our natural areas. And many emerging areas are coming into play. For example, avian influenza is a huge pandemic that is panning out in parts of North America, probably Europe, and it might come to Asia as well. And we have a very large poultry industry, and we might require some, the wild varieties of fowl, which is the red jungle fowl or the gray jungle fowl, and its genomes to help us guide how to overcome this pandemic if we do get affected with this pandemic. And the only native population of the undomesticated jungle fowl, the chicken, is in India. Globally, there is nowhere wild chicken in the world, and the domesticated chicken is the most abundant bird globally. So if we have a pandemic, then we have to resort to accessing the wild bird and understanding its genome and how it has the ability to cope with a viral infection like H5N1. So I think the present amendment will be put to challenge, or there will be some obstacles that we might have to cross on how we make this possible and how we allow the industry to benefit from the important bioresources that we have. And from the top of my head, I can think of these issues.
Yeah, thank you, Dr. Vasudhel, for your important inputs, especially pointing out the pointers for the narrowing scope for stakeholders vis-a-vis the important points that you spoke on was more related to aquaculture and poultry part that you spoke, that plus the ease of access, how is it going to impact the businesses and the challenges that might come through from them, and it might lead to overexploitation in certain terms, and maybe it might lead to extinctions of wild varieties, which may be the key to addressing the pandemics if they occur in certain populations.
Yes.
In wildlife, as I understand. So we go to the next panelist, Dr. Mahendra Darokar. Dr. Darokar, as I already said, he's a chief scientist at TMD and at Innovation Center, Mumbai. And he was also the part of the team from our CSIR, which participated in amendment of the act and giving inputs from CSIR along with Dr. Darokar, along with Lipika, were participants there. And I would like to pose a few questions to him in which directions he can give his talk, a brief talk on that. And the first most important questions that I would like to pose to Dr. Darokar is, what is the impact of Biodiversity Amendment Act, which has been amended in 2023, vis-a-vis, the research, and because you come from plant sciences background, research vis-a-vis plant biosurveys, collections of bioresource for doing research, and these collections from certain R&D oriented industry for utilization of these bioresource for product and developments and all. Secondly, what is the impact on, as Lipika had also said, that collaborative research, there is an impact of amendment in collaborative research within nation and out with international agencies also. So what is the impact on collaborative research, vis-a-vis R&D and vis-a-vis IPR protection, and how is CSIR and public sector organizations impacted from that? So two questions.
So before Dr. Darokar speaks, just if you are not aware, Dr. Darokar has been a researcher at CMAP. So he comes with the perspective of both doing wet lab research as well as now he's into R&D management. So I think he can speak on behalf of both. So over to you, Dr. Darokar.
Yeah, thank you, ma'am. Thank you, Dr. Bhanu. Good morning to all the participants, panelists, Professor Pandit. Thank you for giving me this opportunity to speak on the impact of this research, these amendments of Biological Diversity Act. I will start with that. Madam said I was in CMAP as a R&D scientist, and it's medicinal aromatic plants. A lot of collections and surveys used to happen. The scientists used to go on the collections and surveys. So there was a mandatory permissions even visit the forest. So it would start from that, and before we go for the collection or even in only the survey, a lot of permissions were mandatory for that. But I think now these amendments have made I think the life easy for the researchers, especially for the Indian citizens, and there are a lot of as Dr. Lipika said, there now become some liberal provisions that even the foreign nationals, they don't have to take prior permission, but they have to just register for doing such activities. So I'll start with the biosurvey. The biosurvey, if it is to be done for the research purpose, then I think it is for Indians. It is now there is no restrictions on that, but the foreigners, like Section 3(2%, as Dr. Lipika said, earlier they had to take a prior permission from the NBA, but now they will have to just register online. I think that has become very easy now as far as this surveys is concerned. The the important point was any biological resource which has to use as a reference material or as a standard the material. So especially for those the collaborators which are of not Indian origin, they are of foreign origin, they used to have to take the prior approval from the NBA to enter into that. They use that as the biological, as a standard material, even standard material, not for any commercial purpose or any utilization for further research. It's only just for as used as a reference material. But now I think it's just those people, they have to just register on the online portal being developed by the NBA. And they're acknowledged instantly, and the portal, immediately they will get the instant acknowledgement that you have been registered, and they can use the material as a reference material. The second aspect associated with this is the transfer of the material. So again, this transfer for transferring this material. So the Indian researchers, if they had to transfer the material to their foreign collaborators, they had to take a prior permission. But now NBA has liberalized this, that they have to register only. And the Indian citizens are exempted from this approval and registration. And I think this is, but there was again a question during those discussions whether this for this using this reference standard material, why even registration is required. But there was a clarification that then if you don't register, then it will be difficult to track the users of those biological resources, especially access from the Indian origin. So for maintaining those, or tracking those users so that it doesn't lead to the biopiracy sort of things, so that is required. And I think this is the good amendment in the Act. There's only registration is there, and that instant acknowledgement. So no approval required, just an acknowledgement that it is registered, the person has been registered, and he can now, the material can be transferred. The other important, as Dr. Bhanu said, the collection of especially the plant genetic resources from the wild. This was again a very difficult task, but now this amendment has made it very clear that all those cultivated medicinal plants, especially, and those the material, the biological material, which is traded as a commodity. So they will not fall under this Act. So no permission is required, except that Section 3(2%, those who are not Indian citizens. For them, the permission, the registration would be required. So I think that is, as I said, I had also said the researchers used to have a lot of problem for accessing those material, especially plant genetic resources from the wild. Now it has become the very, very convenient for the Indian researchers. Another aspect Dr. Bhanu mentioned is the collaborative research. So whether it should be permitted between all the institutions, including the private organizations who are involved in the research, And there, this collaborative research, it is now, as per the amendment, that is this Section 3, as Dr. Lipika has mentioned, will not apply to the collaborative research, whether the projects they are involving transfer or exchange of biological resources or traditional knowledge between the institutions, including the government or this government-sponsored institution or the private entities. But for the collaborators, if they are from the other countries, then they will have to have fulfill the conditions they are mentioned in Section 3. That as they are foreign register, so they might have to register for on the NPA portal, but no prior permission is required. But if that research outcome, what you call the research results, utilization of the research result is concerned, then they have to take the prior permission, not before the commercialization. If there has to be commercialized that research output, then the permission of the NBA is required. Otherwise, the registration for the foreign national is, I think, is sufficient.
If I may just intervene here, I'm sure many of our colleagues joined online would have this query also. When you do an MTA, that's material transfer agreement with a foreign entity, and that material transfer agreement is only for evaluation of your material, right? Could be a biological material or a derivative thereof. So if they have to do the evaluation also, is let's say the material is going from India. So do we only register, and this query is both to Dr. Dharokar as well as Lipika, do they register, or does that foreign entity need to take permission from the NBA, even for this MTA for the purpose of evaluation? Because many a times, in PMD, these kind of agreements, draft agreements do come, and there is always this query whether we need to take or we don't need to take. So, Dr. Dharokar and Lipika, any of you?
Ma'am, they will be needing NBA permission because there is no question about anything about for what purpose it is being transferred. If it is being transferred,
it is only for evaluation. That's only for evaluation.
Act doesn't mention anything about evaluation or other things, so it has to be there. But when it is a collaborative research between Indian government organization and the same or similar organization in the other country, then in that case, Section 3 will come.
So that means it's a government organization in India as well as abroad. A government organization.
And it is a collaborative research between government institutes in India and similar institutes in other countries.
Okay. But what about, let's say, an industry, a company abroad,
in that
foreign client of ours who wants to evaluate?
In that case,
it's to inform to the NBA that such things are being taken.
And so is it only registration or permission?
Approval.
Okay.
Now, in collaborative research project, if I'm not wrong, sir, is has to be approved by the concerned secretary of
Yes. It has to be central government.
All that is there. But the NBA, because it's a biological material, that is where the material transfer agreement comes into picture. So that is what I thought I can ask, because we do get these kind of draft agreements and these kind of queries. Yeah, please.
Yeah.
Sorry, continue.
Yeah, I think I'm almost done. One more thing, even Dr. Pandit has also mentioned about the codified, and Dr. Lipika has also mentioned. So the permissions and approvals will not apply to the codified traditional knowledge of this cultivated medicinal plant and its products. And as you was mentioning that local people and communities that are residing in that particular area, or they want to use that material, including the growers and cultivators of this biodiversity, and those Vaidyas and Hakims and the registered Ayush practitioners, like the doctors, the BMS and BHMS, those doctors. So they will not, the restrictions will not apply to these. So I think this is again the very important amendment. So relief to the medicinal practitioner of Ayush field and those Hakims and Vaidyas, basically. There is one more, like as far as this benefit sharing, but I just briefly touch on that. That benefit sharing also, now there is they have some relaxation. One important amendment is the compounding of offense. Like earlier used to be very hard punishment for those who are not abiding to the laws. But now the benefit sharing and those things, the settlements can be happen out of the court, out of the legal things. And that is again, I think, one of the very important part of this amendment as far as the legal part is concerned. So I think I'll stop here. Thank you again, Dr. Banu.
Thank you, Dr. Dharokar. And you have given very good key points on how especially in the field of plant science and biosurveys and collection of biological resources, how the new amendment is facilitating research, especially in public sector organizations, and plus how the collaborative research is also being benefited as the key point of taking permissions and is now removed from it. Only the results of transfer of R&D wherein it is going to the commercial aspect, then only we need to take permission and we need to sign ABS agreements. So it is facilitating research in that context, that a lot of administrative issues are removed for doing R&D, especially for organizations like CSIR and similar R&D organizations, wherein biological resources are involved in research. Further, the permission for filing IPR has also become easier. The patents can be granted without the permissions, and these kind of aspects are actually very positive in terms of doing research in our country. So further, if I may ask the next speaker, Dr. Alka Rao, if she has joined. Dr. Alka Rao, if you are there. Don't think she was actually involved in some other meeting also. So we might have to wait for her. I will, if she's not joined, Dr. Alka Rao, is she there? If not there, we'll go to. Alka Rao is not here right now. So we will go to Dr. Archana Chugh. She's a professor from IIT Delhi. And as I already said, she has been very active in research and, of course, in biosciences and related aspects, but she has been a champion for IPR and governance issues in IIT and has been in the standing committee, has been appointed as a director's nominee in IPR standing committee at IIT Delhi. And I would hold a few pointers and you may, Dr. Shajo, you may then like to speak on those aspects. So you have been involved in biodiversity issues for quite some time, and you are aware of its impacts. So new amended act, both Dr. Dharokar here and Dr. Lipika has already spoken a lot about the act. Some pointers of what it is, how it is facilitating research have been pointed out by Dr. Dharokar. Some key points about what are the drawbacks has been pointed out by Dr. Karthikeyan Vasudevan from our CTMB lab. So I would like to ask you a few pointers on which you can indicate and you can give your, a few minutes of your talk would be that the impact of R&D in R&D institutes, academic institutes like IIT. What is the impact which you feel from your side is coming on institutes, educational institutes like IIT Delhi, R&D organizations? Of course, we have spoken. You will also be able to, please, you also feel free to speak on that also. Plus, there are certain aspects of decriminalization of in the act. So how is it, going to impact the conservation part and biodiversity maintaining part in the country, in India specifically and around the globe also? While we are doing involved in research, those results, research results are being, patented. IPR is generated, and we are filing the IPR for that. And those IPRs, the issues regarding the IPRs, further, these IPRs are done for transferring the technologies for general benefit of the public. So when we are doing technology transfers, and how does this amended act facilitate transfer, and whether there is a positive impact or there would be some negative connotations to the utilization of biological resource when the results are transferred to the industry? How does it impact the biological resource and biodiversity per se? So over to you, Dr. Archana.
Yeah, thank you very much. Thank you, Dr. Bhanu, and thank you, Dr. Vibha, for giving me this opportunity to present my views. Biodiversity, of course, has been very close to my heart. Although I'm a molecular biologist by training and have been working on peptide-mediated therapeutics for the last decade. But, always I have felt there has been an intersection of the IPRs with the life sciences, and we cannot escape them at one or the other point. And being in the IIT system, where there is a lot of emphasis on doing translational research and being surrounded by, the civil engineers and the chemical and electrical engineers who have been, on the consultancy panels, it is the life sciences which has to, look up to these departments and get more into translational research rather than getting into the basic research here at IIT Delhi. So with this aim, I feel that it has been a big breather for us having these amendments. As a researcher, I would say, in IIT Delhi, that, personally, I have felt many times that NBA was a little troublesome for us. Like I've been working with horseshoe crab-based peptides, and whenever it was a synthetic peptide, but still I had to get the NBA approval for filing the application. So, the application would get stuck and you want to do it as fast as possible because for many reasons, even if I'm not going for commercialization immediately, still, my student has to publish the paper and I'm not able to apply for the patent. So we are waiting for the NBA approval to come. So, it has various impacts in various dimensions. And I really felt that, as a researcher, it has been a big breather for us, a sigh of relief that at least we do not have to take the approval right away. We can continue with our research. And later on, when we are moving towards commercialization, we have to intimate to NBA about this or register with NBA. And I think that with time, a lot of things will unfold. A lot of confusions are there. A lot of clarity is needed. For example, for the value-added products and the derivatives. This, I feel, is something which is very overlapping for me. Although, both of them have the same content that they should not have the genetic material. Lack of genetic material should be there, but still, I think there is some confusion, and probably eventually the courts will clarify, or some guidelines have to be in place to give us the clarification. So overall, I think going for a patent has become easier. The interaction with my, patent cell FITT is much more harmonious now because they know when we are working on biology, and especially when we are working on therapeutics, it is all the more challenging to get the patents. We all know that. Diagnostics is still easier. So when we are talking about medicinal plants, we are talking about therapeutics in most of the cases. So that way, I think it is a step easier for us now to go ahead. And also, what I feel is that excluding PVP, the plant variety protection, is also a big relief. It basically it is good not to merge the both and avoid the confusion. Anyways, a lot of confusion will come, as I perceive, with novel life science technologies. When we are talking about synthetic biology, we are creating novel organisms, and also the AI, which we have completely ignored. So, within 10 years, I think we really have to revisit all our acts again. Unfortunately, even in the Patent Act, biotechnology per se is not spoken about. And in biotechnology, India has moved ahead much, much more ahead of the law that way. So, fortunately or unfortunately, the challenges have not come, to that level that we have to give a revisit immediately. But yes, there's no way out. We have to revisit even biodiversity law, keeping in this thing in mind. And also, what Dr. Karthikeyan said, there are few things. As a researcher, I'm very happy with certain changes in the law because it gives me freedom to move ahead. My thought process is not stopped that I have to take approvals and go for these things. But I do think that the law has a narrow stand right now. I completely agree with him for this thing, and especially marine biodiversity again has not been touched upon. And it is so very, very important having India, such a huge coastline, and so much of research, especially by the healthcare sector, pharmaceutical sector, especially for the anti-cancer compounds, is being conducted on the the marine organisms. So that is something which is perplexing to me, and I think it is definitely perplexing to the authorities too. That how do we imbibe, or how do we bring in marine biodiversity within the same framework of the laws as terrestrial? We are talking about agriculture waste being exempted. What about all these waste which is generated by using these shells and all? So these are also further used. So there is no exemption, no mention of that. This is something which is very concerning to me. And but one thing which makes me happy while going through the act, in the definition of India, or the scope of India, it is mentioned about the EEZ, as well as the oceans and all the terrestrial species, the terrestrial space, as well as the airspace and all has been covered. So at least some mention has started coming in now. So, but eventually I think the act will have to deal with the terrestrial life and with the marine life or the biodiversity separately, because India is rich as equally as in terrestrial life as it is in the marine biodiversity. So it is, I think, high time that we should be talking about it among ourselves within India, that how do we deal with that? It is complex, I know, it is very complicated, but we have to make space for this, because otherwise, as Dr. Karthikeyan said, we are ignoring certain stakeholders, which will play eventually a very important role in the pharmaceutical sector or the healthcare sector per se. So this is something which is concerning to me. And regarding the technology transfer, of course, what has been mentioned, I think technology transfer definitely in FITT Delhi, IIT Delhi, it has become easier with this because MTS we do sign, and they are signed through the FITT here in IIT Delhi, and the technology transfer, because we have now clear guidelines in that sense that we do not need the permission of NDA right now to carry out just the research. At least that can be done easily. So yes, a lot of relief in that sense. And I hope that technology transfer in the case of the field of biological sciences probably will become a little eased out. But again, at the same time, when we are talking about the collaborations, I still think that we really need to be very vigilant, because there are loopholes. There are loopholes in the act which can be very easily oversighted, and Biopiracy directly has not been mentioned anywhere, not discussed anywhere. And once we are giving too much of liberty to even to the Indian entities, like Ayush people or the let's say, the other collaborators, the industry, pharma industry, they have some component of the people from abroad as well. So somehow that balance, but it's like wait and watch situation right now with the law. There are some of the things which are very welcoming, giving the ease to the Indian citizens, specifically Indian researchers, and holding a tight noose for the foreign contributors or the people who are accessing the biodiversity of India. But at the same time, we have to be on guard, because if we give too much of leeway to the pharma industry for using the biodiversity based products, the conservation and sustainable use becomes a question. And especially if the Ayush people and the other people who are able to access now with the the biodiversity without giving any access and benefit sharing concept with the local people or the local communities, like the Kani tribe, the rise of Kani tribe, the socio-economic impact. How would we, contribute in that sense? That remains a little enigmatic to me with this change in the biodiversity laws.
Yes, I'm there. I've joined already.
Yeah. So this is something in brief, which I feel that, there are several plus points. As a researcher, I'm very happy. At least I don't have to think about, accessing the biodiversity and, wait for the NBA approval. This has been a real big hindrance. I have personally felt for 3 of my patents, really felt for 3 of my applications, waiting. And, perhaps probably it was not clear even at the level of the NBA. Several things. So we always felt that biodiversity laws have been, the act has been the new baby actually among all the, acts of IPR. So, and also, Biodiversity Act, I think per se cannot be seen alone. It needs to be in harmonization with the Patent Act and also with the PVP Act. So PVP has been clearly shown that it is out of bounds now for this thing, which is good. But at some place, again, we would come back to refer to the PVP Act, because when we are talking about new technologies, when we are talking about creating new organisms, when we are talking about biosurveys and all, or the AI, somehow I feel that harmonization among this triangle between the Patent Act, PVP, and Biodiversity Act will need an evaluation or a revisit. So that is in brief, very brief, my viewpoint, and I hope I have been able to address the questions you have asked, Dr. Bhanu.
Yeah, thank you, Dr. Chugh. The most important part, that point that you made, that the importance of harmonization of these 3 acts, Patent Act, Biodiversity Act, and PVP. Importance of creating new organisms while doing your research, and what is the impact on science. Plus, another important point that you said, though the research has become very easy, become comparatively easier right now due to the new amended act. However, there will be some loopholes. There will be some pointers which the commercial establishments will be able to exploit. And we cannot go outside that. And time and again, the acts are always put up for reviews. Yeah. Seeing that there are certain loopholes and they are being met according to the times. So important parts that the concerns that you addressed was about marine biodiversity, and there was nothing being touched on that. And marine biodiversity, of course, India has, as you said, that there are India has a very long coastline. So, and not only for research in these areas of, as you mentioned, about pharmaceutical developments or development for marine, not only from, fauna, but also from flora. We have a lot of research being carried out on marine flora in CSMCRI, algae and all. And we are generating a lot of biofuels. As you said, biopharmaceuticals are there, part of that. So there is a lot of research in that area. also, we have a lot of indigenous species which are part of exports. It
Yes.
comes under WTO that we are exporting some very important species which are not available abroad, and this adds to the economy of the country. So
Yeah.
these some lobsters and a lot of marine shrimps and a lot of indigenous marine bioresources which kind of forms a very good export foreign revenue earner for our country.
Yes.
And the pointers that will come in that, if there are any issues, as you said, it is not being addressed. So maybe such issues will be taken up as and when we come to these points.
Yes.
And so thank you.
I think in between, Professor Pandit had raised his hand. So, Professor Pandit, I think you'd like to comment on this.
Sorry, I am coming again after my submission.
We want you here because
मेरा
you work very
देखिए
well
मैं
also.
आईपी स्ट्रेटेजी का प्रोफेसर हूँ, तो इंटरवेंशन मुझे लगा कि it is appropriate intervention which is required here, so I have raised the hand. विभा जी एंड अर्चना जी, मेरा एक सुझाव है कि मतलब we can think of who will host this, but एक वर्किंग ग्रुप बनना चाहिए on this kind of research which we want to encourage. मतलब कैसे इसको आगे ले जाएंगे और कहाँ, in which area there is a gap, जो marine biodiversity की भी बात की, तो where there is a gap and certain amount of research can really bring the economic significance as the output for us. तो इसके ऊपर कुछ विचार करने के लिए एक क्लोज डोर मीटिंग भी बुलाते हैं. मे बी विभा जी यू कैन, बिकॉज यू हैव होस्टेड दिस, तो आपके मतलब चेयरमैनशिप में हम ये मीटिंग में भी पार्टिसिपेट करें. बट लेट्स हैव अ क्लोज डोर मीटिंग and bring some kind of a working group wherein we will drive the focus, because CSIR एक बहुत ही useful intervention ला सकता है इसमें. और मेरा strongly मानना है कि आज के समय में इसकी भारत को आवश्यकता भी है. तो ये working group, it may be informal also, nothing to be formalized, because formalize करने की चक्कर में हम काफी सारा एजेंडा ड्रिवन जाते हैं and then we may lose the track. So informal discussion quarterly फॉर्म में भी अगर हम करें तो भारत में बायोडाइवर्सिटी और ट्रेडिशनल नॉलेज एसोसिएटेड जेनेटिक रिसोर्स के फील्ड में हम आने वाले 2 दशकों में अच्छी लीडरशिप ले सकते हैं. तो मेरा एक हम्बल सबमिशन रहेगा कि ऐसा एक मीटिंग बुला के एक वर्किंग ग्रुप बाद में उसको वर्किंग ग्रुप में कन्वर्ट कर सके, तो एक अच्छा हम इंटरवेंशन कर सकते हैं. ठीक है,
जरूर प्रोफेसर पंडित, आपका जो सुझाव है वो हम जरूर करेंगे आगे. And we'll soon organize a kind of a brainstorming where people, who are associated with this aspect of research can come together. Maybe online only, because online, that way you can connect many people together within the shortest time possible.
So पहली मीटिंग के लिए सॉरी विभा जी, मेरा आग्रह रहेगा फिजिकल बुलाइए. हम लोग दिल्ली आ जाएंगे, कोई चिंता नहीं है. दिल्ली इतनी बार आते हैं तो एक बार और, लेकिन फॉर अ गुड कॉज दिल्ली ट्रैवल करने में इसके लिए स्पेशली भी आना पड़ा तो मैं आने के लिए तैयार हूँ.
जरूर हम ये मीटिंग ऐसा जरूर ऑर्गेनाइज करना
जरूरी है.
जरूर, एंड इन फैक्ट हम जरूर करेंगे प्रोफेसर पंडित. And I think soon enough we will organize such a meeting, or maybe a brainstorming, a one-day brainstorming on the Biodiversity Act, and we'll try to have, of course, unfortunately today we could not get people from NBA और MOEFCC, because NBA टीम का हमें पता चला वो लोग नायरोबी में है on some official discussions. So we said, okay, maybe some other time, but we'll definitely get them also. And the entire research team, which is working on different aspects of biodiversity. In fact, chat mein aap dekhiye to there are very interesting queries that have been raised. One of them related to coal. There is Ravi, I think Ravi Kiran, and he said, should we seek clearance from NBA for filing IPR for coal? So coal is in fact, derivative of biological material. Will it be considered a derivative, or we can, consider it a mineral?
विभा जी सॉरी, यहाँ मैं थोड़ा लीगल इंटरवेंशन कर रहा हूँ, एंड ऑफ कोर्स पुटिंग a seed for the new thought on this. जो सेक्शन 6 है वो कह रहा है इन्वेंशन बेस्ड ऑन बायो रिसोर्सेस, और दोनों चीजों में एक कॉमा लगाया हुआ है, तो बहुत सोच समझ के ये कॉमा बताया है, एंड द कॉमा हैज अ लीगल इंटरप्रिटेशन. उस सेक्शन 6 में जो कॉमा के बीच में इन्वेंशन बेस्ड ऑन बायो रिसोर्सेस जो कहा है, पहले तो वो इन्वेंशन है या नहीं ये डिसाइड होना चाहिए. इन्वेंशन अगर है तो वो इन्वेंशन बायो रिसोर्स रिलेटेड है या नहीं ये कंक्लूड होना चाहिए, और ये कंक्लूड होता है तब उस एप्लीकेंट को कॉम्पिटेंट अथॉरिटी का अप्रूवल लेना है. तो आज की प्रोसेस में कहीं ना कहीं थोड़ी क्लैरिटी लाने की आवश्यकता है. होपफुली रूल्स के द्वारा भी मतलब MOEFCC अभी बात कर रहे हैं, काफी सारे स्टेक होल्डर कंसल्टेशन भी कर रहे हैं, हमारी भी मीटिंग वगैरह हो रही है, लेकिन ये चीज कंक्लूड होना जरूरी है. कंक्लूड होने के बाद ये एप्रोप्रिएट अथॉरिटी जैसे कि NBA है भारत में, उसकी अप्रूवल की आवश्यकता रहती है. तो ये लीगल इंटरप्रिटेशन है सेक्शन 6 का. तो थोड़ा और भी विचार करने की जरूरत है. इट इज नॉट लाइक वी बाकी उसमें भी सेक्शन 6 के सब क्लॉज 1, 2, 3 है, हर एक के लिए कैसा है, इन रिस्पेक्ट ऑफ अ ट्रिप्स इसमें क्या होना चाहिए. तो ये सारी बातें हमारी 1 डे मीटिंग जो आपने प्लान करने का सोच रहे हैं उसका हिस्सा बनना चाहिए, ताकि एक बायोडाइवर्सिटी और बायोटेक्नोलॉजी में रिसर्च पर्सपेक्टिव से एक अच्छा टोन सेट होगा, और काफी अच्छा रिगरस 1 डे ब्रेनस्टॉर्मिंग हम इनवाइट कर सकते हैं. तो इट इज अ सबमिशन फॉर द एज अ फूड फॉर थॉट फॉर द नेक्स्ट मीटिंग.
जरूर, थैंक यू. हम जरूर करेंगे, एंड वी विल टेक दिस फॉरवर्ड. आई थिंक ओवर टू यू भानु प्लीज. एंड
थैंक यू डॉक्टर पंडित, आपने बहुत अच्छे विचार प्रकट किए इसमें. आई विल गो विथ योर डायलेक्ट, एंड आई एम आल्सो फ्रॉम नॉर्दर्न रीजन. तो आपने बहुत अच्छे विचार प्रकट किए अबाउट द टेकिंग फॉरवर्ड ऑफ दिस forum and having meetings so that we can have further discussions. And एक बहुत अच्छा point जो आपने रेज किया कि जो कॉमा है एक्ट के अंदर, उसका क्या इंटरप्रिटेशन निकालते हैं, उसका मतलब क्या निकालते हैं, उससे क्या इम्पैक्ट होता है रूल इंटरप्रिटेशन के अंदर. ये आपने बहुत अच्छा पॉइंट रेज किया. एंड हम ये देखते हैं कि जहाँ पे भी रूल मॉडिफाई होते हैं, रूल दिखाई देते हैं, हम छोटी छोटी कॉमा फुल स्टॉप्स का इंटरप्रिटेशन जब तक नहीं रखेंगे तब तक जो भी टाइपिंग मटेरियल है उसमें बहुत ज्यादा उसका इम्पैक्ट आ जाता है. एंड इट कैरीज ऑन फॉर इयर्स टुगेदर. It carries on for years together unless and until that act or the rule is modified. So बहुत अच्छा पॉइंट आपने बोला कि ये बहुत एक एडमिनिस्ट्रेटिव इशू आ जाता है, इंटरप्रिटेशन रिलेटेड इशू आ जाता है, और it becomes kind of a following on for long time. So thank you for such inputs also, and you are such a visionary in this field that we are always benefited from your suggestions and points and pointers that you indicate. I will now invite the last panelist, Dr. Alka Rao. And as I said earlier, Dr. Alka Rao was part of CSIR IMT team, Chandigarh, and she has recently taken a role as advisor in FSSAI for standards and food additives related matters. And Dr. Rao, are you there?
Yeah, she's there.
So I would request you to open your camera, please, so that it will be easier to
interact with
you. Yeah. So Dr. Rao is you are visible now. So the questions that I would like to pose to you, on which you can give your brief talk, would be on you being part and associated with CSIR IMT in the microbial type tissue culture collection center. And the questions that I would like, and you have been part of the Committee on Biodiversity also, as a part in National Biodiversity Authority. She is a part of the committee also. So the questions that I would like to, on which you can, give your talks, is mostly related to microbial culture. First of all, impact of BD Act on, the bioresource in terms of microbes, their access, important, the impact of Act on access, and its, the deposition part. Why important? What is the importance of deposition in terms of IPR and in terms of Biodiversity Act? So what are the pointers now, and what are the impact of amendment of the Act on the deposition requirement of microbials for India and for IPR maintenance abroad also? Over to you.
So thank you so much. Thank you so much for inviting me for this panel discussion. I hope I am audible and visible. And पहले तो मेरा नमन, हमारे बहुत सी चीजें तो मैंने उन्नत जी से ही सीखी हैं। वो NBA के मेंबर रहे और मेरे सीनियर हैं, और बहुत से बातें हम लोग साथ ही करते थे जब एक्ट अमेंडमेंट के समय पर। और माइक्रोबियल कल्चर कलेक्शन और माइक्रोब्स एज बायो रिसोर्स, हमने बहुत सारे सेशंस हुए जिसपे हम CSIR का जो है मुद्दा लेकर आगे बढ़ते थे। तो रिसर्च जो है और IPR, ये दोनों ही शेयर्ड इश्यूज रहे उन्नत जी के और हमारे, यानी कि CSIR के। तो मैं CSIR की साइंटिस्ट रही हूँ और अभी भी हूँ ही, और NBA की मेंबर हूँ, तो दोनों हैसियत से ये काम हम करते रहे। सवाल आपके बहुत सारे हैं, तो मुझे नहीं लगता कि मैं एक ही गो में आपके सारे सवाल का जवाब दे पाऊंगी, बट मैं चैट में जो देख रही हूँ कि वी हैव ZSI एंड BSI, we should have microbial survey of India. I totally echo this. This is the way forward. Microbes अभी भी ऐसा बायो रिसोर्स है जो हम देख रहे हैं ट्रेड के पर्सपेक्टिव से भी। It is a wonderful unrecognized बायो रिसोर्स। बहुत बड़ा नहीं है, तो शायद लोगों को नेकेड आंखों से दिखता नहीं है, तो इसको कोई जो है बायोडाइवर्सिटी अथॉरिटी बहुत इसको कभी-कभी हल्के में ले रही है, जो कि अभी भी जारी है। और हमारी NBA की जो मीटिंग्स होती हैं उनमें ये मुद्दा चलता ही रहता है कि माइक्रोब्स को थोड़ा सा हमें अलग तरीके से डील करना चाहिए। तो क्या इशू है, जैसा कि पहले PBR है, PBR में माइक्रोब दर्ज ही नहीं है, तो आप उनको बायो रिसोर्स की श्रेणी में कैसे लेंगे? क्योंकि PBR वो ऑथेंटिक डॉक्यूमेंट है जहां पर माइक्रोब्स होना चाहिए टू काउंट इट एज बायो रिसोर्स ऑफ द कंट्री। सो PBR में हमारे सारे रिपोजिटरीज के कैटलॉग दर्ज हो जाने चाहिए। ऑलरेडी डिजिटल PBR आ चुका है, इसे ऑपरेशनलाइज करने का प्रोसेस शुरू हो चुका है, तो हमारे जितने भी माइक्रोबियल रिपोजिटरी हैं उनके कैटलॉग उसमें आ जाने चाहिए। वो सबसे बेहतर साइंटिफिकली वैलिडेटेड कैटलॉग हैं, दूसरे पीबीआर के मुकाबले में सुपीरियर साबित होंगे। ये एक चीज है जिसके लिए बार बार मैं एज ए एक्सपर्ट मेंबर इस इशू को रेज कर रही हूँ और थोड़ा थोड़ा इसकी तरफ अभी मूवमेंट शुरू हो गई है। एक्ट की अमेंडमेंट के पहले या बाद में, दोनों ही स्थिति में इस मुद्दे का कोई इससे कोई नफा नुकसान नहीं होता है, क्योंकि पीबीआर का मैंडेट पहले भी था, आज भी है, पर इसके की तरफ कोई एक्शन नहीं हो रहा है। दैट इज द ओनली लिमिटेशन। उसमें हम भी जिम्मेवार होते हैं, वो लोग, वो सब साइंटिफिक ऑर्गेनाइजेशन जो कि रिपोजिटरी मेंटेन करते हैं, अपनी तरफ से हम कोई एक्टिव प्रयास नहीं करते हैं, ना उस लिंक को लेने की कोशिश की जाती है जिससे कि पीबीआर को अपडेट किया जाना है। और ये हमारे लोग बैठते हैं, सब जगह बैठते हैं, एक्सेस बेनिफिट शेयरिंग के कमिटीज में भी बैठते हैं। मैंने खुद कार्तिकेयन जी को याद है मुझे, एक एक्सेस बेनिफिट शेयरिंग का हम कोई मुद्दा, और उसमें हमारे साथ सीडीएफडी और सब हम जुड़े हुए थे। ऐसा नहीं है कि हमें पता नहीं चल रहा है कि क्या चीजें हैं, बट हम भी प्रायोरिटाइज नहीं कर रहे हैं अपने एंड पे। तो शायद हमें प्रोएक्टिव होना चाहिए, हमें घुस के अपना हक ले लेना चाहिए। वो एक तरीका होता है, मांग के ले लेना चाहिए, जैसे भी हो सकता है, पर ये करना चाहिए, पहला काम। दूसरा है कि आज की तारीख में बहुत सारा ये बायोटेक्नोलॉजी वाली बात बिल्कुल सही है, प्रोबायोटिक जैसे कि एक एरिया है, तो ऑलरेडी डीबीटी संज्ञान ले चुकी है, गाइडलाइंस आ चुकी हैं। अभी FSSAI इज आल्सो कमिंग अप विद GMO and it is in the advanced stage at the moment.
Dr. Alka, I think
जी
Dr. Alka, I think आपकी bandwidth थोड़ी कम है, so my suggestion is you can switch off your video, so probably you'll get a better bandwidth.
Right.
Thank you.
Right.
Yeah, please continue.
So am I audible? Okay.
Yeah, much
No,
better.
thank you so much. Okay. So दूसरा जो है कि NTSC, वहां पर भी हमें प्रोएक्टिव होने की जरूरत है। जो NTSC वाली लिस्ट है, अगेन मैं बोलना चाहूंगी कि ये हमारे सेक्शन 40 का सब्जेक्ट हुआ। सेक्शन 40 में अभी जो अमेंडमेंट है उसके मुताबिक एक्सेस ऑफ कल्टीवेटेड मेडिसिनल प्लांट्स, एग्रीकल्चरल वेस्ट and other species as notified in addition to the biological resource items as NTSC. Exemption of NTSC is subjected to registration as per the regulation made or as may be prescribed. तो यहाँ क्या हुआ है, बहुत सारा रेगुलेशन की परिधि में चला गया है। उनकी आवाजें सुन रही है अभी, कुछ किसी का शायद माइक ऑन हो गया है। सो ये यहाँ एक तो रेगुलेशन के परव्यू में काफी कुछ आया है, और जैसा जितना मैं समझती हूँ और जानती हूँ, हमारे जो माइक्रोबियल टाइप कल्चर कलेक्शन को जो भी लोग ऑपरेट करते हैं, तो उनका ये मानना है कि जो हमारी टाइप स्ट्रेन्स हैं उन्हें सीधे सीधे NTSC में डाल देना चाहिए, जिससे कि वो जो दिक्कत हमें सेक्शन 3 के और फिर वो फर्दर रिसर्च ट्रांसफर और वो वाले मुद्दे हैं, वो सॉल्व हो जाने चाहिए अगर हम उन्हें ट्रेड की आइटम बना देते हैं, जो कि कायदे से ठीक भी है, क्योंकि हम ATCC से बहुत कुछ ट्रेड टर्म्स पर खरीदते हैं। ATCC की स्ट्रेन्स है, और टाइप स्ट्रेन का रिसर्च से बहुत स्ट्रॉन्ग कनेक्शन है। टाइप स्ट्रेन के बगैर रिसर्च नहीं होती है, वो एक रिसर्च की क्रिटिकल रिक्वायरमेंट है। तो उसे अगर NTSC में हम डालते हैं तो दोनों ही फायदे होते हैं, रिसर्च को भी दिक्कत नहीं है, वो फर्दर ट्रांसफर ऑफ रिजल्ट वाले क्लॉज भी नहीं लगते अगर वो NTSC रिजल्ट का NTSC लिस्ट का पार्ट बनता है। तो प्रोविजन में घुसने का कि आपको डिमांड करनी होगी, रिपोर्टरीज को आगे आके लिख के देना चाहिए, उन्हें बताना चाहिए कि इंक्लूड अस इन NTSC एंड व्हाई इट शुड बी डन एंड इट इज डूएबल। ये तो एक लिस्ट ही है ना, लिस्ट में नाम ही तो डलना है, और ये ट्रेड की आइटम है, आपके पास प्रूफ है, आप दे रहे हैं, DSMZ बेच रहा है, ATCC बेच रहा है, सभी कल्चर कलेक्शन बेच रही हैं कल्चर्स को। ये बात ठीक है, नागोया प्रोटोकॉल के बाद कुछ बदलाव हुए हैं कि बायलैटरल ट्रीटी है, बट टाइप स्ट्रेन उस तरह का रिसोर्स नहीं है। ये रिसर्च के लिए एक आइडेंटिफाई रेफरेंस मटेरियल है, तो रेफरेंस मटेरियल बिल्कुल ट्रेड की ही चीज होती है। तो ये कुछ संज्ञान है जो हमारे रिपोजिटरीज को एज अ रिसर्च इंस्टीट्यूट हमें लेना चाहिए, और हम वेट करते रहते हैं कि NBA में कोई सोचेगा हमारे लिए। तो जैसे मैंने कहा, उनको माइक्रोब दिखता कम है, उनको बड़े बड़े जानवर दिख जाते हैं, बड़े बड़े पेड़ पौधे दिख जाते हैं, माइक्रोब कम दिखता है समहाउ। तो वो एक एक्शन है जो मुझे लगता है एज अ CSIR साइंटिस्ट आई ऑलवेज वी शुड कीप ऑन पुशिंग। बाकी मुझे लगता है ऑलरेडी उन्हें जी बता चुके हैं आपको सेक्शन 3 और 6 का काफी कुछ, उनसे ज्यादा मेरे पास ज्ञान नहीं है, ये मैं कह सकती हूँ। तो अगर कोई स्पेसिफिक पॉइंट है जो आपको लगता है मुझे ही जवाब देना चाहिए, तो मैं जरूर अटेम्प्ट करूंगी। थैंक यू।
Thank you, Dr. Alka Rao, for your important, briefs on what are the issues that related to microbes that we are facing, and we are not having such speak in NBA about microbes. So this should be taken up, and organizations like CSIR should put up those issues with them. And of course, microbes become very important bioresource, not only in, as you mentioned, lactobacillus or something related to, not only for food related issues, but also for pharmaceuticals and other related issues. Microbes become very important. And as Dr. Archana Chuk also said, that new microbes have been coming up with the research that is going on in biotechnology, and new microbes have been created. So these kind of issues should be taken up, and organizations like CSIR are on the forefront to take up these issues. So thank you so much for your this thing. There is 1 or 2 questions in chat box that I will pose. This is how the microorganisms carry the traditional knowledge for ABS purpose. Should we seek clearance?
वो कोल का हो गया, so maybe microbes का for ABS.
Yeah, how the microorganisms carry the traditional knowledge for ABS purpose. This is one question. Dr. Alka Rao, would you like to take this question?
Or Professor Pandit, any of you? Yeah, Alka, please go ahead.
So I would like to hear Professor Pandit first.
बीच में थोड़ा क्वेश्चन के समय वॉइस क्रैक हो गया था. Request if you can repeat the question.
Yeah. So the question is how the microorganisms can carry the traditional knowledge for the ABS purpose. Now they are asking this question for ABS purpose.
Certainly, this is a debatable question. मतलब ये ऐसा ही है, चिकन पहले एक पहले. तो
सर एक ही आता है पहले. अगर आप evolutionary point of view से जाएं तो only single cell organism will come first. So egg will come first as per my.
Certainly the knowledge. I am answering from the knowledge perspective.
Yeah, yes sir, yes.
जैसे माइक्रो ऑर्गेनिज्म एग्जिस्ट करते हैं, ठीक है ना, लेकिन माइक्रो ऑर्गेनिज्म के साथ एसोसिएटेड नॉलेज nowhere in the literature it is reported. If we see that it is a traditional knowledge associated with genetic resources, and where the knowledge exists, merely utilizing the microorganism for the advancement of a scientific research and the knowledge is not falling under the ambit. That is my personal view. I'm sure NBA will not agree with me. Or Alka ji may have also some other view, but certainly something which is existing, like गंगा के पानी में माइक्रो ऑर्गेनिज्म होना, और उस माइक्रो ऑर्गेनिज्म का क्या यूटिलाइजेशन है और कैसे ये गंगा के पानी को साफ रखता है, ये नॉलेज कहीं अवेलेबल नहीं है। अगर कोई रिसर्चर इस पर रिसर्च करता है, so that is a advancement of a knowledge. This amounts to something where this knowledge is a novel. We don't know whether the person can claim the patent or not, because we have not received the patent. But this advancement should be encouraged. अभी उसके ऊपर ABS लगाना, that is something where I am not in agreement. मेरा बहुत स्पष्ट व्यू में बता रहा हूं, क्योंकि मैं हमेशा से ही एक शार्प व्यू के लिए ही के साथ ही अपने विचार व्यक्त करता हूं। तो मेरा मानना है कि ये जेनेटिक रिसोर्स एग्जिस्ट करते हैं, हाँ करते हैं, लेकिन उसके एडवांसमेंट को रोकना या उसके ऊपर रिसर्च को रोकना, ये कहीं ना कहीं गलत अप्रोच होगा साइंस के लिए, साइंटिफिक एडवांसमेंट के लिए।
तो प्रोफेसर पंडित, थैंक यू। जो आपने गंगा के पानी की बात की, तो इनफैक्ट हमारे यहाँ नीरी नागपुर ने ये स्टडी किया है, और कुछ बैक्टीरियोफेजेस है जो इसको साफ रखते हैं, लेकिन बिकॉज बैक्टीरियोफेजेस को आइसोलेट नहीं कर सकते ऐसे, और उसको आइसोलेट होते हैं तो वो लिविंग नहीं रहते, तो इस करके उस चीज को पेटेंट एप्लीकेशन उसमें नहीं फाइल हुआ है। बट डेफिनेटली एज यू सेड, advancement of science होना चाहिए, and I think all of us are on the same page for this. But Alka, what are your thoughts?
Yeah, so thank you, ma'am. कैसे माइक्रोब के सिनेरियो में ABS लगता है? ऑफ कोर्स ABS तभी है जब आप कमर्शियल यूटिलाइजेशन करते हैं। तो माइक्रोब इंडिया का किस कमर्शियल यूटिलाइजेशन के केस में ABS का केस बनेगा? फॉर एग्जाम्पल हमारा कांजी है, हमारा एक कर्नाटक में रागी से गंजी बनता है, हरियाणा में एक राबड़ी बनता है बाजरे से। तो स्ट्रेन लेवल का नहीं डेवलप किया है हमारे ट्रेडिशनल फूड में कि कौन सा वाला स्ट्रेन क्या टेस्ट, बिकॉज आप देखिएगा सब केसेस में अलग फ्लेवर अलग टेस्ट आ जाता है हमारे ट्रेडिशनल फूड में। ये है ट्रेडिशनल नॉलेज कि ये वाला स्ट्रेन से ही ये वाला टेस्ट आएगा। तो आप देखेंगे जो इंटरनेशनल नेदरलैंड या जहां पर भी डेयरी के प्रोडक्ट्स बहुत अच्छे इनोवेटिव प्रोडक्ट्स बनते हैं, वो स्ट्रेन भी स्पेसिफाई करते हैं। आप पर्टिकुलर स्ट्रेन डालेंगे तभी वो टेस्ट का, दही वो कंसिस्टेंसी का आपको एक मतलब फ्लेवर भी मैटर करता है, दोनों चीजें तभी आएगा। तो वहां ABS आ सकता है अगर हम अपने घर में अपने जो रेसिपी हमारे देश के जो ट्रेडिशनल फूड हैं उनमें माइक्रो ऑर्गेनिज्म के कैटलॉग डेवलप कर ले, वो जानकारी। तो उसमें मुझे लगता है हमने ज्यादा काम ही नहीं किया है, दोनों ही फूड बॉर्न पैथोजन भी और फूड से रिलेटेड जो माइक्रोब असेसमेंट है टिपिकल। तो ऐसे कुछ सिनेरियो में आ सकता है ABS का केस। सो थैंक यू।
डॉक्टर उन्नत पंडित कुछ बोलना चाहते हैं आप? बोले सर।
नहीं, अलका जी के साथ मेरी हमेशा ऐसे विषयों पर बहस, जब मैं MCA का मेंबर था, जब हमारी मीटिंग थी तब भी होती थी, और यहाँ CSMCRI से अनीशा सिंह जी ने भी उनका समर्थन किया है। तो मेरा काउंटर एक आर्ग्यूमेंट है, नॉट जस्ट प्योरली एन एकेडमिक डिस्कशन, बिकॉज अगर समय है तो हम, मुझे लगा 2 मिनट का समय है तो मैं ये अपना व्यू भी विचार रखूं। देखिए, सपोज हमने जैसे प्रोबायोटिक कर्ड है, ठीक है ना, वहां पर भी माइक्रो ऑर्गेनिज्म यूज होता है, ठीक है। कहीं रोज फ्लेवर्ड का कर्ड भी बनाया है, तो वो भी एक माइक्रो ऑर्गेनिज्म, टिपिकल माइक्रो ऑर्गेनिज्म को जेनेटिकली मॉडिफाई करने के बाद यूज हुआ है। तो कहीं पर भी नेचर में ऐसे माइक्रो ऑर्गेनिज्म एग्जिस्ट नहीं करते हैं। ये एक एग्जिस्टिंग नॉलेज है माइक्रो ऑर्गेनिज्म की सीक्वेंस का, जिसको यूटिलाइज करके हमने एक वैल्यू एडेड प्रोडक्ट बनाया है, which is again one improved microorganism. Or value added product is excluded in the Biodiversity Act. तो वैल्यू एडेड प्रोडक्ट एबीएस में से एक्सक्लूडेड है, तो उस पर कहीं पर भी एबीएस लागू नहीं होता है। उसकी डेफिनेशन में ही अगर हम देखेंगे तो ये चीजें एक्सक्लूड की गई है बायोडायवर्सिटी एक्ट। तो हम सारे ही रिसर्चर के लिए ना सिर्फ साइंटिफिक जर्नल, साइंटिफिक रिसर्च पढ़ना उपयोगी है, हमें ऐसे लीगल अंडरस्टैंडिंग को भी एस्टैब्लिश करना जरूरी है, ताकि कहीं पर भी हमारा रिसर्च आगे जाके ऐसी कॉम्प्लेक्स सिचुएशन में या ऐसे डेडलॉक सिचुएशन में नहीं फंस जाए। अदरवाइज इतना बड़ा काम करने के बाद, इतना सारा रिसर्च फाइंडिंग लेने के बाद अगर हम कहीं ऐसी डेडलॉक सिचुएशन में फंस जाते हैं तो लीगली उसका हल निकालना होता है। तो ये भी एक बहुत जरूरी है, ठीक है ना। तो दिस इज अगेन द डिफरेंट व्यू फ्रॉम व्हाट अलका जी हैज मेंशन्ड, बट again both the views are correct. In both the views we need to have a proper legal position getting established. Thank you.
Yeah, thank you, sir. So we will like to take other questions. This one. We have ZSI and BSI for zoological and botanical survey. We should have microbial survey of India to tap the rich microbial biodiversity for value addition. This is just a comment. This is not a question. Next, please. So this is also a comment. The next question is, my question about, this is saying, sir, ma'am, my question is about practical monitor benefit shares of NBA approved patented products. How National Biodiversity Authority gets its benefit as per share mentioned in benefit agreement between patent and NBA, the patented product. I think this question may be taken if somebody is volunteering from the Dr. Chugh. Would you be like to take this question? I think Dr. Chugh is not here. So maybe somebody from
is here.
Is here.
Dr. Archana Chugh.
Yeah, sorry. Yeah, could you please repeat it for me? Actually, there was somebody in my room and I was just talking.
No issues. So the question is about practical monitored benefits shares of NBA approved patented products. How National Biodiversity Authority gets its benefit as per share mentioned in benefit agreement between patent and NBA. So this is widely known answer, but though the question is posed, so we would like the panelists to answer this question.
Yeah, so I think it depends. As per my experience, what I have seen is it depends on case-to-case basis for NBA.
Okay,
Dr. Pandit? Yeah.
Can I just
Yes, Dr. Karthikeyan, please.
So this is more on an implementation level. Actually, a follow-up question of this would be that since the Act has been now amended, there should be rules, and this will come under the rules of Biodiversity Act, not the Act itself. So there are provisions of what is the amount to be collected and how it is dispersed through PMCs and other things through the state biodiversity authorities. So they are doing it based on those rationale. So this is not pertaining to the Act itself. The Act doesn't define those, the percentage share.
It is defined in the ABS agreement. Actually.
Yeah, in the ABS agreement.
The amount that is being collected by NBA, how it is distributed to the the local SSBs or for maintenance and conservation of biological resource. Anybody from our
Shikha or Lipika can Shikha. Good afternoon, everyone. So, sir, what happens is once we execute the ABS agreement with the NBA, then yearly we have to give a status report based on each financial year on our status of that patent which has been granted or still it's in prosecution, that what are the commercial leads on that, and in case if the party has commercialized it, whatever, how much we have earned and what, as per the agreement, we give the share to the NBA. CSR Labs has been actively sharing the benefits in terms of monetary revenues with the National Biodiversity Fund on a yearly basis.
Wonderful.
Yeah, so there is no dedicated percentage which goes to NBA. So that's what I meant.
Case
To case basis. And just like we used to have, we have this National Gene Fund or something like that. We don't have that with NBA, unfortunately.
Yeah. Yeah.
So next question, please scroll down.
So I think there was a scientist from CIMAP who initially wanted to ask something.
Dr. Negi, Dr. Arvind Negi, I think he wanted to ask.
Okay. So Dr. Arvind Negi, if you'd like to pose your question now.
Yes, ma'am.
Yeah, please.
My question is from Lipika ma'am. Ma'am, I have taken a plant part and I have isolated one molecule. Then I transformed that molecule, and after 2-3 steps, I got an impressive bioactive molecule which I want to go for patent. So for this type of work, should I have to go through NBA? NBA? Should I follow that NBA authority permission?
Because you have already changed that molecule, you have already derivatized it. Now it is your contribution to it, and it is not something naturally existing or a biochemical entity existing in a biological resource. So you may not need NBA permission for this. And presently, after the Act being amended, for in case you are going for IP protection, you will not be needing NBA permission for this at all. You'll not be needing NBA permission.
Okay, thank you, ma'am. And one more query I have.
Please go ahead.
Yeah, we have an international collaborative project sponsored by Government of India, and under this project, I have to get some of the plant molecules which are being to be evaluated outside India. So in this case, should I take the permission from NBA?
So which is your collaborator outside India?
Is it a company? It's a company or?
No, it is government institution outside India. That is also government institution.
So when you are transferring that, it basically relates to transfer of biological resource. So in this case, I don't think you are transferring a biological resource. It's a chemical entity, I think.
Pure molecule, yeah. Pure molecule I have to.
In that case, you will not be needing any NBA permission in that regard. Okay. But when it comes to transferring a biological resource, then NBA permission may be required. But if it is a collaboration with a government entity and you are a government entity, then the exemptions are there under the Act under Section 5.
Dr. Dharokar, you want to add on to that?
No, I think she's right. Yeah.
Okay.
She's right.
So if there are any further questions, somebody can.
I think there's something more on the chat.
There is. People can raise their hands also if they want to ask questions.
Okay, so it's Alka stating that many countries are not accepting deposition of microorganisms for taxonomy purpose. Depository outside India needs prior approval from NBA for supply of the culture. This is a hurdle for the taxonomy or novel species description from India. How to tackle the challenge? So Alka, you are so Dr. Alka Rao, maybe you'd like to respond to this.
She herself has asked the question.
No, it was Dr. Syed has asked this question. Dr. Alka?
He might have left actually. Okay.
Yes, ma'am.
Yes, she has left. She's just messaged. She's left. She was. Okay. So can somebody else take this question. Yeah, Dr. Karthik can take.
Yeah, I can just pitch in not exactly what the question raises on microbes, but essentially a lot of biological repositories globally have our species, that is Indian species, like British Museum, the Smithsonian and all those places. So, accessing those samples, the museums have to get into an agreement with the user. And if you're sending samples from here to those museums, I think that can be avoided because we have our own repositories like Zoological Survey of India and many other national museums where we can store our samples. I think IMTech is already recognized as a national repository for microbes. So we can have our own catalogs and our own cataloged species. So sending it outside is not required. I personally feel. I mean, for organisms, we follow this guideline. I don't know for microbes what is the issue.
Dr. Karthikeyan, there's a question for you from CLRI. It's there in the chat box.
Yeah, I saw that. Yeah.
You saw that. Yeah. So maybe you'd like to. Yeah.
Yeah. See, this again, like how Dr. Pandit mentioned, this is a value-added thing now. So I don't see anywhere this coming under BD Act. Just he gave a very nice example of probiotics and how many new innovations in dairying and final products have been done. And what CLRI is doing is value adding it with better tanning processes and all that. And the hide, raw hide, has become a leather. So this doesn't fall under BD.
Regarding this value-added product, this is a very confusing term which was used in the in the definition of biological resources and always debated by all the stakeholders. So, during the amendment of the Act, we have tried to we have requested NBA to get this particular term clarified in the Act or in the rules. Some of the rules have been amended now. Again, raise the same thing that this term is there in the section and needs clarified, and whatever clarification is there in the and all is not sufficient for us to understand. And now actually they have committed that it will be there in some sector specific document, but we are expecting that this terms needs to be clarified so that
yeah, so Lipika, thanks for that update. But I feel we have to set precedents. Many of these acts follow precedents. Good practices need to be followed. Good interpretations need to be followed. Many acts do not specify exactly how each case should be used. So we have to create those precedents, and good practices need to be streamlined. And this is, in my opinion, if we go and refer back to National Biodiversity Authority, give us the option of telling what is value added, they will spend another 3 years looking at it. So we should start with doing the good practices. Thank you.
I echo Karthikeyan Vasudevan ji. देखिए वैल्यू एडेड प्रोडक्ट CSIR के रिसर्च में और CSIR द्वारा किए जा रहे रिसर्च में सारे ही साइंटिस्ट के लिए CSIR ही एक गाइडिंग डॉक्यूमेंट बना सकता है कि क्या वैल्यू एडेड प्रोडक्ट है और उसको कैसे इस एक्ट के आधार पर और पेटेंट एक्ट के आधार पर एप्रोप्रिएट साइटेशन वगैरह देना चाहिए. ये तो विद इन दी परव्यू ऑफ CSIR है. और CSIR जैसे TKDL में भी किसी ने कुछ नहीं किया था, CSIR ने लीड लेकर काफी अच्छा एक एस्टैब्लिशमेंट किया है. वैसा ही CSIR IP टीम के तत्वावधान में हम कैसे ये वैल्यू एडेड प्रोडक्ट को भी हम थोड़ा क्लैरिफाई करें ताकि ये सारे रिसर्च के आउटपुट को हम सही मायने में कमर्शियल लीड की ओर ले जा सके. तो मैं पूर्ण रूप से सहमत हूँ कार्तिकेयन जी से कि अगर नहीं है तो किसी और पर आधार नहीं रखना चाहिए, हमें शुरुआत करनी चाहिए क्लैरिफिकेशन की.
Sir,
yeah, Dr. Archana, please.
सर आई थिंक जो इंडस्ट्री है वो वैल्यू एडेड प्रोडक्ट्स को अलग से देखती है और उनका ऑफ कोर्स कंट्रीब्यूशन जो है वैल्यू एडेड प्रोडक्ट्स में बहुत डिफरेंट है एज कंपेयर टू एकेडेमिया और इफ वी आर टॉकिंग अबाउट CSIR। तो मुझे लगता है कि दोनों को मिलके बैठ के करना पड़ेगा ये, उसका इंडस्ट्रियल इम्पोर्टेंस बहुत।
Another agenda for one-to-one meeting. कितना बढ़िया, एक के बाद all reasons to meet physically and discuss for the day-long meeting.
ये टॉपिक ही ऐसा है इसमें।
Sure, we'll definitely have this, Professor Pandit and Dr. Archana. I think Indrani would like to add to this.
I just want to add one comment. पेटेंट एक्ट और बायोडाइवर्सिटी एक्ट का मतलब सम्मिलन होना बहुत जरूरी है। As Dr. Pandit rightly said, that value-added products. Now, what lacuna I find in the research going on in CSIR mainly, because we deal with that, is that in patent act the use and the method of treatment are not patentable. So, they attribute a function to the new traditional knowledge or genetically modified organism. But the researchers failed to amend it in a form of a composition with experimental support so that we get the IP protection on that. So that is my comment, that we need to work on those lines also to have a win-win situation for both sides. That's my comment. Thank you.
So there are two views in your comment. एक तो रिसर्चर को समझना है कि कैसे इसको पेटेंट स्पेसिफिकेशन में टेक्नोलीगल डॉक्यूमेंट में हमें प्रेजेंट करना चाहिए। सो एक उनको आईपी की ट्रेनिंग होनी चाहिए और आईपी में कैसे प्रेजेंट किया जाए उसकी बात होनी चाहिए। और दूसरा जो है विच इज मोर इम्पोर्टेंट कि कैसे इन चीजों को हमें मतलब क्लैरिफाई करना है अपने डॉक्यूमेंट में कि वेदर इट इज अ वैल्यू एडेड प्रोडक्ट और नॉट। रिसर्च लेवल पर भी वैल्यू एडेड रिसर्च होता है, क्यों नहीं होता है? अगर वो वैल्यू एडेड रिसर्च नहीं है तो कैसे वो नॉवल बनेगा, इन्वेंटिव बनेगा, इंडस्ट्रियल एप्लीकेबिलिटी बनेगा?
नहीं सर, कई बार क्या होता है, एज एन एग्जांपल अगर अश्वगंधा का उन्होंने फंक्शन बताया तो वो पेटेंटेबल नहीं है क्योंकि यूज है, बट उसका एक्सपेरिमेंट या सपोर्ट एज अ कंपोजिशन नहीं होता।
गिव मी 30 सेकंड्स, ठीक है ना? तो अभी अश्वगंधा का ये एग्जांपल दिया है, तो अश्वगंधा की मतलब कैंसर की केमोथेरापीटिक साइड इफेक्ट को सबसाइड करने वाला जो एलिमेंट है, इट इज अ पेटेंटेबल सब्जेक्ट मैटर।
यस,
कहीं लिटरेचर में नोन नहीं है। और दूसरा, कहीं पर भी मतलब इंडिया का एक ट्रेडिशनल एक हमारी पोजीशन रही है, कहीं पर भी हमने पेटेंट एक्ट को किसी भी चीज के साथ को रिलेट नहीं किया है। हेल्थ केयर में भी बाकी जगह पर जैसे ऑरेंज बुक है, तो मतलब यूएस में पेटेंट एक्ट को और वहाँ की रेगुलेटरी अथॉरिटी जो सारे ही न्यू ड्रग्स को अप्रूवल देती है, उनका क्लोज कोलैबोरेशन, क्लोज एफिलिएशन है, मतलब लिंकिंग है। हमारा ये लिंकिंग नहीं है। हमारा पेटेंट ग्रांट होता है अलग उसके मानांक के आधार पर, और ड्रग रेगुलेटरी अथॉरिटी उसको अपने ड्रग्स एंड कॉस्मेटिक एक्ट के आधार पर, उसकी गाइडलाइन के आधार पर उसको ग्रांट करते हैं। अभी यहाँ एक नया एलिमेंट जोड़ना, बायोडाइवर्सिटी एक्ट और पेटेंट को, जिसके लिए ये ट्रीटी हुई थी, ठीक है ना? तो ये अब जाके संभव हो पाया, और उसको भी किस हद तक हमें करना है ये भी हमने यहाँ पर, हम मतलब वर्ल्ड में सुप्रीम स्टैंडर्ड लेकर बैठेंगे जिसमें हमारे साथ कोई नहीं है, सो दैट इज नॉट गोइंग टू सस्टेन। आज हमारी स्थिति ये है, हम वर्ल्ड में एक्सट्रीम स्टैंडर्ड लेकर सबसे ऊपर बैठे हुए हैं, जहां हमारे साथ हाथ जोड़ने के लिए हाथ में हाथ परो के ग्लोबल साउथ में या डेवलप्ड नेशन में भी हमारे साथ मिलकर अनुसंधान करने के लिए लोग नहीं है। तो ऐसी पोजीशन पर कितना सस्टेन कर पाएंगे, तो ये भी एक हमें सोचना चाहिए। तो हमारे बायोडाइवर्सिटी एक्ट में भी उचित बदलाव लाने होंगे, हमारे पेटेंट एक्ट में भी उचित बदलाव लाने होंगे, और इस ट्रीटी के बाद भी कैसे आने वाले समय में ये सारी चीजें एग्जीक्यूट होंगी, या क्या साइंटिफिक रिसर्चर का एस्पेक्ट इसमें कवर होना चाहिए, इस पर भी एक शायद मंथन की आवश्यकता रहेगी।
Thank you so much.
Yeah. So another question is, we utilize MTCC microorganism for biotransformation, and since we had good conversion, we are able to apply for patent.
So this is a comment.
This is a comment.
Yeah.
And now the Bellish Chinoy is saying which needs deposition at 2 international culture collection. Now I do not understand this question.
This is a reply to
Acha. Most issue. Some other question.
The earlier one.
Yeah, the earlier one.
I don't know.
I think it's a follow-up of the earlier question, I think.
Yeah. Yeah. So there is no further question. So
yeah. No, this is basically pointing at the earlier question that was addressed to Alka. I think there is a requirement that bacterial taxonomy requires deposition in 2 international culture collections. So let India have 2 international culture collections.
India has. One is MTCC at Chandigarh, one is NCCS, and one is IRI now.
Let us keep it within
agriculture issues.
That's enough. We'll keep it within India and deposit it in 2 international.
Yeah, internationally recognized for IPR issues. These are the only problem is with the deposition of algae and protozoa and viruses, which none of the Indian depositories allow. The deposition of algae, protozoa, and viruses.
Okay. So let us create that, no? Let us have
that has to be created.
We have to. These are priority things that we should create such facilities so that our scientists can access these international repositories.
Actually, NIO will be, I think, considered under NIO Goa has been recognized. So out of 13 repositories, CSIR has 3. One is also for angiosperm for flora, including algae and fungus and lichens. NBRI is also recognized. So this is the information that from our end I would like to share, that 3 repositories CSIR has been recognized. One is at NBRI for flora, including microbes consisting of not bacteria but lichens, for microfungi and algae. IMT is for microorganism per se totally, and NIO Goa for marine flora and fauna. So these are the 3 Indian repositories recognized by Biodiversity Authority. So this is information from my side. And for other microbes, NIV Pune is there for virus related, so bacteriophages and all would be included in that. And NCCS is of course there. NCCS Pune is part of DBT, that is recognized with even internationally for IPR protection also. So these are the repositories. Of course, there are others for BSI and NBPGR, the Zoological Survey of India, National Bureau of Animal Genetic Resources, Karnal. For fisheries, there is National Bureau of Fish Genetic Resources, WII, not IRI, a lot of those are there. So these are the repositories which are recognized by the Biodiversity Authority. And if there are any lacuna in the meeting that you are proposing, we can, of course, discuss, as Dr. Vibha said, these issues. If there are any further questions, Ajit Pratap is asking a question. You may speak.
Yeah. Hello, madam. Good afternoon. I am Ajit Pratap Singh from NBRI. So we are working on this taxonomy of plant. So sometime we face problem. If we stuck to the Biodiversity Act 2002, then to assess any plant resource living organism, we have to take permission from the NBA. So if we want to visit to any area for exploration and collection of the plant, so when we request to NBA, NBA does not reply, and in that case, we go to the CCF. I mean, Wildlife Warden, Chief Conservator of Forest, to take permission from them under section 12 and 28 the 28 of the Wildlife Act 1972. So what I understand that because biodiversity mean to provide means a right to assess the biological resources, but while at institute we want to assess the resource, Biodiversity Act or NBA does not have provision to give us permission to assess the plant. It is only means we get this permission only from the section 12 and 28 of Wildlife Act.
So, Dr. Ajit, maybe Darokar can take this question. Darokar,
Yes. I think for accessing the resources, we don't need the permission from NBA. That's why the provision is not there made by NBA. ये जो आपका जो wild resources वाला है, is a different thing. I think wild से हमें जो collect करना होता है, उसके लिए परमिशन चाहिए होती फॉर द रिस्पेक्टिव एंडेंजर्ड और एक्सटिंक्ट उस पॉइंट ऑफ व्यू से, तो उसके लिए आपको अलग से वहां से परमिशन चाहिए जो लोकल रेंजर्स या फॉरेस्ट रेंजर या फॉरेस्ट ऑफिसर्स होते हैं, स्टेट बायोडायवर्सिटी बोर्ड या स्टेट बायोडायवर्सिटी, वहां से आपको एक्सेस के लिए या कलेक्शन के लिए परमिशन चाहिए होती.
No, so actually, sir, I want to just interfere here. If we need permission from SSB State Biodiversity Board, then it comes under the NBA, because if we are exploring our resource in any state, then Biodiversity Act has provision that prior we have to move to the NBA to get permission. If it does not come under the NBA purview, then we may go to the respective state where I want to explore and collect the plant specimen. So it is covered under the access of the Biodiversity Act.
Yeah.
And
so you don't have to go to.
Practically, we face this problem. We want to survey any area that is going to cover some this protected area also. For example, if we want to means prepare a flora of Uttar Pradesh, so there is Dudhwa National Park, of course, it is included. So to reach other area, yes, we can go without taking permission. But when a rule comes, so at that time, respective State Biodiversity Board can take any action because we have not taken permission from them to explore. So in that case, we do exploration on our own risk. This is one issue. And second, to enter in protected area, NBA and this State Biodiversity Board has nothing to speak on our request. We have to go to the Chief Wildlife Warden under Wildlife Act and for the collection of plant only. Yes. So somewhere there should be some kind of provision where NBA should take it into consideration so that some new provision should be made for those kind of the access of the plant resources. So this is my just.
So the only problem is that the NBA doesn't respond to any queries, and like the patent office has a dedicated help desk, NBA should also provide a help desk to the stakeholders so that we can pose our queries regarding anything. तो आपका जो concern है कि वो जवाब नहीं देते हैं, वो हमारे साथ भी मतलब सभी के साथ प्रॉब्लम है, तो उनको बार बार फोन करना पड़ता है या पोक करना पड़ता है आंसर के लिए. बट आप बिना उनकी परमिशन के एंडेंजर्ड या प्रोटेक्टेड एरिया से मत सर्वे करिए.
Dr. Vasudevan wanted to add something to that.
Yeah, no, I was listening to Dr. Ajit Pratap Singh from NBRI. See, as a researcher in biodiversity, we need to be very conversant with the acts. We need to read the acts before we engage in, getting into our projects. And we cannot excuse ourselves from, from the provisions of the act. If it is a protected area, you have to go to the State Forest Department, and the PCCF and head of Forest Force is the authority. If it is a and the Chief Wildlife Warden is the authority. That is under the Wildlife Act. If it is a wild resource, yes, you need, that is only if it is either a scheduled plant or a protected area. Biodiversity Act, nobody is asking you to take any permission if you are going and collecting a plant from outside any protected area. There is no need. You are a citizen of the country. You are entitled to do this sort of work. So I think we are getting too worried about these acts. And if you read the act, the preamble itself says it applies for citizens. This is not something that applies. If you're a citizen, you don't need to seek permission on many of those. Only if you are developing a product, selling a product, making revenue, which we are not. So, and all the criminalization aspects have been removed, isn't it, Lipika? You mentioned it. Yeah. So there is no need to worry. There is no apprehension that we should have to do our research.
So, amendment it was never there.
So, as a responsible researcher and as a responsible citizen, if we are doing research on biological resource which is collected from protected area, we need to take permission from respective agencies. But as you are collecting resources from anywhere wild which is not protected, you can do that.
Yes.
And there is no requirement for taking permission.
Yes.
So I hope your question is answered. And any further questions?
It's closed now.
Yeah.
So we've exceeded by 1 hour our scheduled time for this, but thank you all so much, for so actively participating and interacting. And I hope, through this discussion, we've been able to clarify quite a few things. And if not, you know who the people there are around to seek out for any further queries that any of our researchers would be having in terms of biodiversity or the Patent Act and the interaction between the two. So, Anu, you can formally close now.
Yeah. So I will take this opportunity to thank all the participants, especially the speakers, Dr. Pandit, who had spared a long amount of time with us. He has been with us for almost 2.5 hours now.
Professor Pandit has just left for another meeting.
So he has left, but I am late in my thanks to him. So further, Lipika from our end, from CSIR, IPO, she has given good pointers on the act, amended act, and what are the features which have been amended. And Dr. Darokar, Dr. Karthikeyan, they have been part of our Biodiversity Day deliberations for last 2 years, and they have given Dr. Karthikeyan Vasudevan on wildlife conservation, Dr. Darokar on plant bioresources. And thank you so much for giving pointed remarks and concern points, sharing the concern points. Dr. Alka participated for the first time this time. She has also left. She has also been able to give pointers on microbial cultures. The first time edition, Dr. Archana Chuk, thank you very much for being with us for the entire day now, almost 2.5 hours. You spared such a good amount of time with us.
Thank you very
out
much.
from your research and sharing your thoughts and your concerns regarding the Act and issues arising from it. I thank my head, Dr. Vibha Malhotra Sane, for giving this opportunity, DGCSIR for agreeing to this panel discussion, my team, entire team at CSIR IPU, SCDD head Mahesh, IT head Dolly for SCDD head for live streaming the program on social media handles, and Dolly also for putting it on website and all. Last but not the least, all the participants who have taken their time to attend the program and post the questions. Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you.
Have a great day ahead.